competition is called a trial advocacy moot, a trial advocacy competition, often called TAC in colloquial parlance. So what happens in a TAC is that you have to examine real life witnesses as if you were doing it in a real court of law. So the organizers of the competition, they will deploy their own students as witnesses. So it could be a murder case, and one of the witnesses could be an eyewitness. One person could play the investigating officer. Many such roles to play, right? So what you have to do in trial advocacy is that you have to chief examine and cross examine live people as witnesses, and by doing that you establish the facts on which you will argue later. There are no established facts in front of you as there are in the first type. So naturally, trial advocacy is much more interesting because it has a lot more activity and fact finding than the other type, but they're also more difficult and require much more skill. So on a very brief level, this is generally the structures that moot court competitions assume in the present day. So moving on, next we come to the second part about how to approach a moot proposition. So this is the part where you apply to be selected for a competition. Your moot court faculty in charge selects you, assigns you a role that you will be a speaker, you will be a researcher, and so on. And now you have the fact sheet in front of you. What do you do next? So the first thing that any mooter, no matter which competition it is, must do, it will be a no-brainer for most of you, is to understand your facts. Okay, the law comes in much later. First, you understand and memorize the facts of the case. I remember a senior of mine who would memorize the facts for every mood that he went for. That even if you were to wake him up from his sleep at say 2 in the morning and ask him a random fact from a mood proposition, he would be able to tell you. And I'm telling you because I have done that. So that is how much command you should have over the facts of the case, and the law will come later. But first, you must understand the facts. Next is to locate the appropriate forum. Now, the forum obviously being the court or the tribunal before whom you will be presenting your case. Now, this is a given in most competitions because most competitions directly tell you that a writ petition was filed before a high court or an appeal was preferred before the high court, in which case you already have the forum before you. You don't need to look anywhere for the appropriate court before whom you have to go. But in competitions that do not explicitly tell you what is the name of the court before whom you will be going, you should be able to locate the forum based on the facts. Again, knowing the facts comes into play here, because if you know the facts, you will know which court has the power to hear this kind of a dispute, right? Because if it's a divorce case, naturally the Supreme Court will not be taking up this matter at the first instance. That's a no-brainer. But how do you know that? Because you know the facts of the case. So first you understand the facts. Second, you locate the appropriate court or the tribunal before whom you will be making your case. And finally, you understand the relief that is prayed for. Okay. Often steps 2 and 3, they mingle with each other. Sometimes it becomes difficult to separate them because knowing what relief you want to pray for tells you the court before whom you have to go, and knowing what court before you have to go, that sometimes tells you what kind of relief you are allowed to pray, right? Because without going into the details, I will very briefly brush up on it, that each court in the Republic of India has certain powers conferred on it by different laws, and a court is only allowed to act within those powers, which in legal terms we call jurisdiction. So each court has its own jurisdiction, and you cannot pray a relief which is outside the court's jurisdiction. So knowing a court or knowing the court before which you have to go tells you what would be the jurisdiction or what would be the relief that the court can grant, and the other way around. So first, when you take the fact sheet or the moot proposition in your hands, these are the three things that you must first do. For the time being, forget research or making arguments or preparing any points of facts or analogies, but for the time being, just focus yourself on these three. Once you are certain, 100% certain that you know these things correctly, which is when you proceed. So once you have got this firmly under your grip, that is when you go to research. Once again, remember that you are before a court. Even though the court is imaginary, it is still a court. You're not giving a lecture here that you will be speaking to laymen who have no understanding or who do not have the sources to verify what you're saying is true or not. You're going before a court of law, and naturally the court is going to know more than you are. So if you're lying, the court is going to find out. Understand that. So because you're before a court, naturally your research should be from selected sources. You cannot just, if your friend tells you that something exists or something does not exist, that cannot be a basis for including that in your arguments, right? Now that's a no-brainer, but I need to state that on the record that confine your research to only a few selected sources and do not go astray and just go to random sources. So what are these sources? So when you want to understand what sources or what sources of information you will be looking for, there is a hierarchy. And if you find two contrasting sources of information from two different sources, then you rely on the hierarchy, and whichever source is higher in the hierarchy, that one will prevail over the inferior source. So the hierarchy is as follows. Constitution of India and other laws, of course, they are number one, because if it's a standard principle of interpretation of the law, that if an act or if the bare text of something tells you what is to be done or what is not to be done, then there is no scope for interpretation and you must do as the law says. So the Constitution of India, of course, being at the top, followed by other laws such as acts, rules, regulations, notifications, orders, and all those, followed by case law. Now, of course, I do not mean to say that case law is inferior to the law or the statute, because it is the job of the judiciary to interpret the law. But that, as I said, it comes into force when there is some ambiguity in the law itself. If the law is clear, then you do not need to consult case law, which is why I say that acts and rules come before case law. Now, once again, case law has a hierarchy of its own. Naturally, everybody will know that a decision of the Supreme Court will naturally prevail over that of a High Court. So if the Supreme Court says that a particular set of facts or law exists and a High Court says otherwise, then naturally the Supreme Court will take precedence and whatever the High Court says can be ignored, because that will not have any value before what the Supreme Court has to say. So within this hierarchy, there is a sub-hierarchy of case law, followed by scholarly works like commentaries and peer-reviewed journals. Now, commentaries, of course, very senior lawyers or retired judges or even sitting judges sometimes, depending on their area of expertise, they sometimes write commentaries. Or there are peer-reviewed journals. Now, peer-reviewed journals are journals that are written, assessed, and debated upon by experts, by academic experts, or by practitioners in any given field of law. So usually commentaries and peer-reviewed journals, they are on the same level because ultimately they are opinions of people. They are not hard law that you can rely on without looking at anything else. But because these are opinions, there can be conflicting opinions, and there is no basis to determine which author or which scholar is superior to which other scholar. And for that reason, commentaries and peer-reviewed journals, they are not very high up the hierarchy, primarily because they are opinions and not hard law, like the Constitution or like acts and rules. And finally, there are other books and articles which are not necessarily written by scholars or by experienced academics or practitioners, but other authors. And such sources do not have a lot of standing in a court of law, and they would only be consulted if the first 3 points which I've mentioned on the screen do not say anything about it. So if there is a point of fact or a point of law on which the first three are absolutely silent, there is no material available, then the court may consider other books and articles. Okay, so when you're in a moot court and when you're in before when you're assessing or approaching a moot proposition and doing your research, this is how you do it. Now, naturally, I need not tell you that sometimes the the moot propositions themselves list down the laws which are to be consulted. For example, if it's a criminal appellate moot, then you will have the offense before you. For example, so and so person was convicted under so and so section of the Indian Penal Code, and now that person has preferred an appeal, the High Court or whichever court, right? So in such cases, you already have the law, the law before you. Say, for example, Section 302 of the Indian Penal Code. So in such cases, you already know what you have to look at, and based on that, you can start researching. For example, in a particular set of facts, murder is said to have been committed, or in a different set of facts, it's culpable homicide not amounting to murder. I apologize for being a bit too technical, but the underlying statement is that most moot propositions will tell you what laws you're supposed to look at, meaning they'll at least give you a starting point. And once you have the starting point in your hand and you do a bit of digging, you will automatically come across other related rules, regulations, case laws, or journals that you are expected to consult. Naturally, they are not going to give you a list of sources from which you're supposed to research. That defeats the purpose of research. But they will give you a starting point from which you will build your case. So this is how you approach a moot proposition. Now, I understand that there might be questions here, but let's reserve all the questions until the end, unless anybody wants to say anything at this moment. Please stop. Okay, so next comes the part of drafting a memorial or a written pleading. So competitions usually provide memorial requirements, and they are highly specific, and they include color of cover page, where appellant usually has a blue cover page and the respondent usually has a red cover page. But that depends from one competition to another. They tell you what font your arguments must be in, the size of the font, line spacing, margins, all that is very clearly given in the rules to most moot court competitions, and these rules are fairly standard. The font will usually be Times New Roman, the size will be 12, line spacing will be 1.5. Now, this I can tell you out of experience that most competitions have identical rules when it comes to making memorials. But if the rules do not so provide, if they do not provide the information that you require to draft a memorial, then you are expected to include the following. Now, these points again, which I'm about to start telling you, they are standard points, and generally they are supposed to be written in that order, in the order in which I'll be telling you, and that is for a reason, which we'll come to in a moment. First is the cover page, obviously, which states the competition name, the parties' names, the case number, for example, civil appeal number 826 of 2017, for example, whatever. The forum, the court or the tribunal before whom you are making your case, and the side. Are you the appellant? Are you the plaintiff? Are you the respondent? Who are you? The side of the case that you are representing, and which will automatically decide the color of the cover page, as I had mentioned earlier. Next is the table of contents. Now, this does not need any explanation, self-explanatory. Then comes the index of authorities. Now, let's go back a few slides. I had told you that you are supposed to research from certain selected sources, which I'm sure by now you all must have dealt with in one activity or another. But whatever sources you consulted for making your memorial or drafting your arguments, everything you're supposed to just copy and paste it on this page. the index of authorities. Whatever you relied on, you're supposed to highlight it here. And the reason for this is that when a judge of a moot court competition is checking your and assessing your memorial, often just by looking at what judgments you have cited or what laws you have consulted, judges are able to form an opinion as to how deeply you have researched. If you have just done some cursory reading and haven't really gone deep into the subject, then your research will reflect differently. Your sources will reflect that. Whereas if you have dug deep into the subject matter and done solid, groundbreaking research, then your case laws and your judgments and the laws and rules that you're relying on will be entirely different. So this is an effective indicator for moot court judges to decide how good your research is going to be. And they also, the flip side of stating more judgments and more case laws is that you're giving the judges more grounds to question you, because it has happened with me that I had cited a particular judgment, and it was my mistake that I had cited the case without scrutinizing the facts of that case. So when I was making a point I was making a submission in a moot court, and the judge just stopped me and she asked me the facts of that case. So I was stumped because I did not have the answer to that. So I found a way to skirt around it, and I did manage to do that. But you should try and avoid that. So make sure that you state everything carefully, but you know what you're stating here. Don't just decorate the memorial with more case laws and more authorities just because it looks good. Just understand that you're giving more exposure to yourself by citing more information. Next comes, sorry, next comes the statement of jurisdiction. Now, as I had mentioned a few moments ago, jurisdiction, simply put, is the power that a court has to hear your dispute. And from where does a court achieve that power? From some law. It's either the constitution or some other act or some rule that gives a court or a tribunal the power to hear your case. So your job here is to find out which is the provision that allows the court to hear your case, the enabling provision. So there will be a provision which says that an appeal from the decision of so and so court will lie to this court. So that court will be your forum, and the provision which says so will be your statement of jurisdiction. So you can approach this by saying that the appellant has approached this honorable court by virus of section so and so act, and you briefly set out what the law says, so that if the judge wishes to consult it, they can do that. So this is the statement of jurisdiction. Next comes the statement of facts, not more than 1 or 2 pages. Now, self-explanatory. It's a summary of the crux of the matter, because usually a fact sheet can go into 10 pages or even 20 pages at times. So this is the absolute crux of the matter which the judge needs to know. Technically speaking, every word on the fact sheet is important and has some bearing on how the arguments will go. But despite that, the facts that are the absolute crux, the backbone of the matter, the backbone of the dispute, without which there would not be a hearing, are supposed to be made part in the statement of facts, and generally do not exceed more than 2 pages for this part. That is for the reason that, as a matter of practice, when you go to a moot court competition and the judges hear you for the first time, they are often looking at the problem for the first time in their lives. Yes, most competitions have a briefing for all the judges, but most judges are completely clueless before they first start hearing you, right? Which is why now a good way to evidence this is that the first rounds or the first hearings in any courtroom, in any competitions, are generally the longest, because that is when the judges are also acquainting themselves with the facts, right? Which is why the statement of facts should be succinct and very precise, so that the judges really know what the matter is all about and they can start asking you questions. Next comes the statement of issues. Now, issues are nothing but questions that are raised before the court, and they are generally provided by the competition. But if they are not, your issues will depend on what the facts are and what you are asking for, the relief that you're asking for, which I had mentioned earlier. So, for example, if you had a contract with some person and under the contract you perform your part and now the other person owes you money. So your relief is specific performance, direct the person to perform the contract or recovery of money, whatever your relief is. But for that, you first need to establish that there was a valid and binding contract. So that will be your first issue. Was there a valid and binding contract in the case? So your issues are directly related to the kind of relief that you're asking for and vice versa. Next comes the summary of your arguments, or as it is sometimes called, the skeleton argument. So just like it is with the facts, your actual fact sheet is more than sometimes 10 or 20 pages long, or sometimes even longer, and your statement of facts is supposed to be a summary of that, just the absolute crux of the matter. Just like that, your arguments can sometimes go into tens or 20s of pages, right? But your summary of arguments is again supposed to be the absolute crux of your arguments, the very the main points, the main bullet points that you are basing your entire case on. That is what goes into this part, the summary or the skeleton of your arguments. And finally, the main part, the arguments, because the arguments will decide how well you perform in your moot court. And generally, you are supposed to draft your arguments in such a way that they follow this pattern. You take a fact, you take the law, and combined, you take the conclusion. For example, you state that there was a written agreement between person A and person B, and under the Indian Contract Act, written agreements are valid and have the force of a contract, provided they meet certain criteria. And those criteria have been fulfilled in the present case, which is why I am concluding that there was a valid and binding contract in the present case. So one fact, to support that you add one law and you derive something from that, which is your conclusion. Okay. So this is the structure that you should ideally follow for all the points that you state. And understand that when I say law, I mean that you should base your submissions on either a case law that has interpreted a point of law, or the constitution, or an act or rule or regulation, and so on, as we had discussed earlier. So fact, you will get that from the fact sheet, and law you will get from these sources. So you combine them and you make your submissions. That is what the structure generally follows. And finally, this is the prayer or the relief that you are asking for. So as I had said earlier, your issues are dependent on your prayer and vice versa. If you are asking for a particular thing, all the things that are necessary to establish that thing will be your issues. Do all those things exist? Because if they do, only then can you get your relief. Only then you can ask for the relief that you are looking. And vice versa. If you have correctly asked the issues, then a combined reading of all the issues will point towards one part, that is the relief that you're asking. So one must be very careful to ensure a degree of coherence between your issues and the prayer, because if they do not synchronize with each other, then your mooting can go haywire. You are asking one set of issues, but you are asking for a relief that has not been argued, that has not been substantiated at all anywhere in your pleadings. So just look at it this way, that the issues are the questions that you're asking, the arguments are your answers to those questions, and your prayer is the absolute substance of your arguments and what you want now that you have proven the substance. That is the pattern that your memorial should take. And what I've just told you is the structure or the table of contents of any standard memorial, with minor changes here and there. For example, some competitions do not require you to write the summary of arguments. In that case, don't. Do not violate the rules. But generally, there are no restrictions of what not to include in your memorial. So in that case, you should include the following, the preceding 9 points, which I just told you. Okay, and outside what is supposed to be in your memorial, there are a few things that participants often carry to moot court competitions, out of which I'll first tell you what they are, and then I will tell you my opinion based on my experiences or of mooting. So first is you carry all the bare acts. So all the bare acts that you are relying on, you must carry them with you, because if you are trying to make a point, if you are trying to interpret the law, then what is the law? The law is the bare act. And you need to have that in front of you when you read it out to the judge. When you recite it to the judge, you need to have it in front of you. And if the judge asks for a copy, you should be in a position to give the judge a copy of what you're reading, which is why it's absolutely essential to carry a bare act. Okay, but there is no need to carry heavy commentaries. You will, those of you who have already been to moot court competitions in the past, you will often see teams carrying bags filled with heavy fat books, and they end up not even glancing at those books even once. So it really does not make any sense to carry heavy commentaries if you're not going to rely on them even once. Some teams carry these heavy commentaries just for the appeal that it creates, just for the effect, the intimidation effect that it creates. If your opponent is carrying all these heavy books and loads of heavy books, then a novice or a beginner might think that their opponent has prepared really well, and there is a lot of material that the opponent has to speak. But do not go on what you see or how heavily armed the opponent is. But you must carry the bare acts, because that is the crux of the matter. That is the law that you are citing. Next, case law summaries. Now, this is one thing that I often do. I did not learn this part, the point number 2. I did not learn that from any senior. In fact, it was my idea that it came to me on one of the competitions that I went for. That when you are making a submission, or when you are arguing in a moot court, naturally you are going to rely on some case laws. And what this part does is that on a simple sheet of paper, you write down all the case laws that you're looking for, right? You write the name of the case, you write the bench, the names of the judges that decided that case, a brief summary of the facts in a few sentences if you can, and the ratio or the final decision, what the court actually held in that case and why you're relying on it. And the reason why you do this is because the problem which I mentioned earlier, that I had cited a case law in my memorial and the judge asked me for the facts of that case and I had no straight answer to that. So to avoid situations like that, if you have a sheet of case law summaries with you, then if the judge asks you the facts or the bench of any case, even that happens, just because the judge is fascinated and wants to know more, the judge will often ask you who was sitting on the bench or who authored that judgment. In that case, it is beneficial to have such a sheet with you. You may not use it, you may not need to use it, but if push comes to shove, having this sheet helps you, and it helps you a long way. It helps you impress the judges. The judges know that you have prepared well and you have a sheet, and whatever the judges are looking for, you have the answer to that. So bare acts and case law summaries are a must carry. You must have these two things with you, no matter which moot court it is. Even if it is your intra moot court or an international level moot court, make sure that you carry case law summaries always with you. And finally, there is compendium. Compendium is nothing but a compilation of all the judgments that you're citing. Now, sometimes in the bigger moot court competitions, I have seen participants cite hundreds of cases, literally hundreds of cases. I'm not exaggerating the figure. There was once a memorial of one of my opponents where almost 120 cases were cited. In addition to other laws and other reports, 120 judgments had been cited. And if you want to compile so many judgments together, sometimes judgments run into hundreds of pages, as we have seen with so many in the recent past. Some judgments are even as short as 2 or 3 pages long. But when you're going to combine so many judgments together and print them, it is often a waste of paper and your money, because Very, very rarely is the case that the judge actually asks you to give a physical copy of the judgment. When you cite a case law, the judges will generally know that what you're saying is the truth because they have handled those and read those case laws so many times, and they themselves have cited those case laws before real judges so many times that when you cite it, they know what you're saying is true. But sometimes, and once again, it's very rare that the judge actually asks you to submit a physical copy. And in that case, it helps to have a memorial. But speaking in terms of reality and in practice, the possibility of the judge asking you this is far too less for you to waste so much of paper and your money on making a compendium. So if you don't if there is really no need to, do not waste your money and paper on a compendium. It is more often than not a waste of everything. So now once again, this is my opinion. If somebody else tells you otherwise, you're more than welcome to follow whatever suits your conscience. But personally speaking, I have wasted my money and my and paper generally because I did make heavy fat compendiums and carried them to moot court competitions with me, and nobody asked me to show them even once. Not the opposing side, not the not the organizers, not the judges, no one. It was a waste. So if you want to prevent that, do not make a compendium, but make sure that you carry the first two. So as far as memorials and written pleadings are concerned, this is what I have to tell you. And now we move on to the main part, which is oral presentations. So there are a few points that I can tell you. First is to be humble and courteous, but not mechanical. Now, I have faced this uh, when my opponents are arguing, of course, that sometimes for the sake of being formal, they drone on and on in a calculated mechanical way as if a robot is speaking, not a human. The judges are not interested in knowing how well behaved or how formal you are, but they really want to know what substance you have. So, of course, because they are judges and they are your seniors and your superiors in the profession, you are expected, in fact, you are required to be humble and courteous before them. But do not be formal or humble to the extent that you are mechanical. Okay, that does not go very well with most judges. Next is speak to the judges and avoid reading unless you are quoting a judgment or law. So, as opposed to a debate competition or elocution, when you are on the stage and there are hundreds of people listening to you, here it is usually you and maybe two or three people on the other side. So it's more like a conversation between people than a lecture. So if you were speaking to your professor or if you were speaking to your senior, you would not constantly read from something to them, right? You would talk to them. You would explain whatever you have in words as if you are conversing with them. And that is what you're expected to do. There is a reason it is called a submission. You're submitting something before the judges. You're not going there to read something or recite something. That is not your job. Because if you're ultimately going to read from your memorials, the judges can simply say to you, hey, we have a copy of your memorials. We can also read. Why do we need you if you're just going to read from your memorials? Right? So to avoid that embarrassment, make sure that you look at the judges in the eye and you speak to them. Of course, exceptions are when you want to quote a sentence from a judgment or read from the bare text. In such cases, you obviously have to uh, look down and read from a book, but that's exceptional and very, very rare. So generally, you should be speaking to the judges. Next is try sticking to the sequence used in your memorial because the sequence takes a very logical turn if you see it in your memorial. First come the jurisdiction, why you have come before this court, because it has the power, and why, based on the law. Then come the facts of your case. What is the exact dispute that has happened? Next come the issues, and finally your arguments. So there is a very logical sequence here that first you state one thing, and based on what you stated first, you keep following with logical submissions and you make a logical coherent argument when seen as a whole. So that is the sequence of your memorial which you are ideally expected to stick to. But there is a catch. You should always be ready to be jumbled around your points, because if you are very, very lucky, only in such cases you will find a judge that is willing to let you finish what you have to say and only then ask you questions. This happens very rarely. More often than not, you will come across judges that just stop you in the middle of your submissions, ask you a question. That question could be on a point that you're making right now. It could be on a point that you made 2 minutes ago, and you cannot ignore what the judges are asking you. So in such cases, you have to reverse a bit, go back to something that you have already stated, and then once again find your way back to the present and continue making your submissions after you have satisfactorily answered the judge's query. So it also happens sometimes that you are already on your arguments and the judge asks you a question about a fact, or the judge asks you about the jurisdiction. Do I really have the jurisdiction? Should you not have come under some other law? Questions like that. I have faced them in my mooting career. So you should always be ready to be jumbled around your points, because it's not a dream world. So it is very, very rare that you will actually be able to stick to the sequence of your memorial, and the judges will try to twist and turn everything to confuse you. That is where your skill as a mooter comes. That despite all the confusion showered on you by the judges, you should be able to stick to what you have planned and execute that plan. That is your skill as a mooter. Next is answer the judge's questions with a straight answer followed by an explanation, and do not frolic around. So if the judge asks you a question, chances are, or very high chances at that the answer to the question will be a simple yes or a no. If that is the case, just give that answer and then explain why you're saying yes or no. Do not frolic around by saying, I will answer your lordship's queries in my following submissions, or try to give a very long introduction and then come to the answer. That might irritate, frankly, a few judges. So if you have a straight answer to the question, give the answer and then give your explanation. And barring this, what you absolutely need to know, I really don't think that apart from this, there is much that I can tell you. After all, when you go there and when you are in the lion's den, ultimately you find your own way. Just trust yourself, you will find your own way, because everybody mooted the first time in their lives, and everybody had this a few points in their head that I'm supposed to be formal, I'm not supposed to interrupt the judges and things like that. But ultimately, how well and how you actually perform in the courtroom is ultimately based on your gut and how quickly you can think on your feet. Because ultimately, all this mechanical preparation in your head, you might even forget that in the heat of the moment. When the judges are grilling you, you might sometimes get irritated because you know that the judges are asking you stupid questions, but that is their job. The judges know that they are asking you stupid questions, but they are doing that on purpose to irritate you or to anger you. So in such cases, it is your skill not to lose your calm and just stick to your preparation and make the point that you went inside the courtroom to make, and only then come out. So this is what I have to share with you guys about oral presentations. And finally, I do have some practical advice for all of you, which is off the record. You would not find this advice given to you generally in any mooting workshop, because maybe it is not very friendly advice, but I'm sure those who have attended this webinar, you have done that because you are interested in mooting. And as present or prospective mooters, there are some things that you need to know, which is this. So results are not always fair. Be ready to face defeat after giving a stellar performance. It has happened with me that you do your best and you even know for a fact that the other side was not that good. The other side flustered, they did not give correct answers, but still you do not win. Still the other side is promoted and you are kicked out of the competition. So just be ready to face such an unfortunate situation, because that happens in the life of more or less every mooter. This also happens next, that competitions may at times prefer to promote selected colleges. And this often happens in those competitions where the home team is also participating. I had this has happened with me also, and this has also happened with a lot of my close friends who have told me this, that a college organized a moot court competition and their own team participated and won that competition. So you all know what principles of natural justice are. One cannot be a judge in their own case. So this is a gross violation of principles of natural justice, but that happens, and you need to be ready to face such a situation. Judges can be partial. This is also a very, very likely possibility. Now, it is possible that if you're arguing a criminal law moot and you are representing the state, the prosecution, and the judge is a defense lawyer or a defense counsel, then chances are that they are more likely to be inclined to support the defense because they do that every day in their life. And they are naturally bound to be hostile to the prosecution because their bread and butter depends on that. So that might manifest in their judging performance in a moot court. And sometimes you might think that the judge was asking my side a lot of questions and not the other side. Happens. Deal with it. You cannot. There are only few things that you can control, and judges is not one of those things. So judges can be partial or biased. You have to deal with it. And finally, at the end of the day, after you have exhausted your preparation, skill, and talent, just leave the rest to your luck and your fate, because of course one might make the argument that there is nothing called fate or luck and you make your own luck. But at the end of the day, things that I have just mentioned, that a college or a team was promoted to the next round despite having given a horrible performance, or just because the judges favored their side, all these things happen. And at the end of the day, at least a part of your success in a moot court competition does depend on luck. So I think this is all the advice that I have to offer based on my experience as a mooter and as an organizer. So I thank you all for listening, and now I am ready to face any questions which any of you might have.
Thank you so much, sir. The wonderful performance and the wonderful presentation as well. It was like full of. So is my voice echoing?
A bit. There is some disruption, but I think you can go ahead.
Is it better now?
Yes, it is.
Yeah. So thanks for that. It was truly a prolific performance, and the practical advices are something which we always look up to, and we really loved that. Sir, if I could just pose the questions which we have got from the attendees of the presentation.
Absolutely. Yes, please.
So we have a question from Sonali. She is asked, can you share some useful tips as to how to find out jurisdiction of the court?
Okay. Thank you for the question, Sonali. Now, as I had mentioned earlier, there are mainly two sources of jurisdiction. There is the Constitution of India, which establishes certain courts, mainly the Supreme Court and all the high courts. And there are statutory courts, such to give you an example, let's say the National Green Tribunal, which finds its origin in the NGT Act 2010, to give you an example. So, depending on which court you're supposed to go to, the enabling provision will be decided. For example, if you're going before a high court, then the jurisdiction will be either the Constitution, which vests original jurisdiction in the high court, or it could be a procedural law, a statute that contains a provision, an appeal provision or a revision provision that tells you to go to the high court. So it's usually the Constitution or some procedural law in which you look for the statement of jurisdiction.
Yeah, thank you, sir. Another question is, may you please share some reliable sources for research and for reading case law summaries?
For reading case law summaries.
Yeah, so the few reliable sources. This is by Muskan. She is a second year student. So she's a pre-law student who, like, we haven't begun with the proper mooting and the core law subjects. So that's by her. The reliable sources for research and for reading the case law summaries.
Absolutely. So, Muskan, thank you for the question, and I'm sure you will uh, get many better answers from your seniors because they will be able to help you firsthand, and I can only offer you some limited insight. So the most authentic source to find information is usually government data. It could be the website of a high court or the Supreme Court, or if you're researching on a very technical point of law or a very technical legal branch per se, then the sources that you can most comfortably rely on are the official government sources. As I had said earlier, I mentioned in the hierarchy of resources that are available to you, peer-reviewed journals and commentaries come much later. Official government sources are higher up the list. So you should start from there and gradually work your way down. But if you're asking me specifically to name sources where you can find judgments, then there are some very renowned search engines like Manupatra, SCC Online, or All India Reporter, which have their own websites from where you can find copies of judgments and their summaries.
Thank
And
you so much.
once again, I'm sorry, I'm sorry. Once again, what I have just told you is very generic advice. And as I had said earlier, you will be able to find more precise answers to your questions based on the facts of each case. And your seniors who are with you in college, they will be in a much better position to guide you in this respect.
Thank you so much, sir. Sir, we have a few more questions. Sir, this is by I can't seem to find the name though. It is a question by a second year student that considering that we are still pre-law students and we still have time to nourish our research skill before we commence with the core law, could you enlighten us on how should we go about the research process as it is one of the most crucial step of mooting?
Okay, now for this question, I'm assuming that when you say research, you're talking about research for a moot court proposition. So for this question, uh, whenever a team is selected for a competition, you will be paired with your seniors for research. So first, of course, the starting point of your research, as I had said earlier, is the moot proposition itself, which will generally give you the name of a law or the name of a judgment or some rule, something else, which gives you a starting point. But how you proceed from that starting point, the seniors from your team who will probably be the speakers will be able to help you because that is the tradition that has been passed on over batches in our college. I have been at the receiving end and the giving end of this tradition, so I can comfortably say that is what will happen with all the pre-law students.
Thank you, sir. Are there any more questions from the attendees? You could post them over here. Or you could just unmute your mic and ask the question to the sir if that's comfortable with you.
May I say something here, Ruja?
Yes, sir?
May I say something, or are there any? All
Sure,
right.
sir.
Okay. Okay. Any students, if you do not wish to answer, if you do not wish to ask any questions just now, or if you don't have any questions just now, you can contact me on Facebook. I am there on Facebook. Just drop me a message saying that you attended this webinar and you had a question. I'll be more than happy to talk to you about it. So
Hello.
that is for all those who do not have any questions just now.
Sir, I guess
Hello.
we have the question. Please proceed,
Uh,
whoever is asking it.
this is Neha here from LLB third year. Hello, am I
Yes.
audible?
Yes, Neha, go on. You are perfectly audible.
Yeah, I just wanted to ask about the memo. While we draft a memo, uh, how particular or how specific we have to be in that?
What do you mean? Could you please elaborate?
As there is hierarchy, like we have to write our facts, jurisdiction, and then argument in advance, issues, and everything.
Yes.
So while framing all those things, is
Uh-huh.
there any particular thing that we are supposed to keep in mind and not write the entire story about, or just particular things about it. So can you just
Absolutely.
elaborate some things and tell how to frame a good memo? Like, while during being a third year student, usually you face problems while drafting it. So we put contents which we are really not supposed to add into it. So could you just tell how specific or how particular we are supposed to be in adding issues or arguments, or what are we supposed to add in the arguments?
Okay, just think of it this way. You will only tell the court what the court needs to know. If you are relying on an act or a provision of the law, or if you're relying on a judgment, they only cite the sentence or the provision that most perfectly fits the matter. Do not write any preceding or following provisions just to increase the length of your arguments. In fact, the shorter your argument, the better it is. So, as I said, whenever you are relying or whenever you're making submissions, you will rely on a fact which will be available to you in the moot proposition, and you will be relying on a law which is either likely to be a case law or something from the statute. So, pick out only those sentences and only those parts of the statute or case law which is most perfectly fitting the provision, and combine that with one sentence from or multiple sentences from the fact sheet which you require to make a particular point. So that is what I could tell you.
So while you frame the one more out, sorry for that, but
That's,
while you frame argument in advance, so in that we usually add a case law.
yes.
So in case laws, how many case laws minimum or maximum we are supposed to add, and not make it feel too tacky for that ki, it is only about case laws or it is only about the argument. So any suggestions that we are not supposed to do in the argument, so that while we present it, it shouldn't get irritated for the front person to read it.
Oh, no, 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 no. There is no minimum or maximum number. And this is a very common question that asking how many case laws there must be in a moot court memorial for it to look good. There is no minimum or maximum number. And yes, what you said is right, that at times some participants just heap loads and loads of cases and judgments to decorate it, and that can get irritating at times. So I would say that you answered your own questions. You need to cite only those judgments which you absolutely need to make a point. For example, uh, there could be one judgment that tells you that gives you 3 points of law, but and there is another judgment that gives you only one of those 3 points. So you can in such a case you can cite only the first case and successfully make the 3 points that you wanted to make, and not cite another case which only gives you one of those 3 points. So here this is some sort of a disguised unemployment. You are citing the second case when you don't really need to. You can perfectly convey the same law and the same logic to the judge by citing only one case. So I would in fact say that you keep the number of cases in your memorial to a bare minimum and cite once again only what you need to.
Okay, thank you so much for that.
So we have,
May I ask a question, sir?
Yes, please go ahead.
yeah, go on, go on.
Yes, sir. This is Anuya Devkar from 4th BA LLB.
Yes,
Am I
Anuya.
audible?
Yes, yes, you are.
Yes. So I have a rather practical question to ask you in terms of the arguments.
Okay.
And it is something I believe that is that only an experienced mooter such as yourself can answer.
Okay.
How do you suggest we deal with judges that are extremely stubborn and are there to simply grill you and not because that seems to be a problem that is faced by every mooter on every moot that they go to. So how do you think we should deal with stubborn judges, and what do you think, how should you deal with grilling given by judges? That is colloquially what we call.
Okay. And every mooter needs to understand this, that the judge always knows more than you. So even if the judge is asking you a silly question or is constantly asking you the same questions in different ways, the judge knows what he or she is doing. The judge is not stupid to not understand your submissions and keep asking you the same questions just for the sake of wasting time. The judge knows what he or she is doing. So The real test of the mooter in such cases is to hold your ground. The judge might deliberately make wrong submissions or state the wrong law to confuse you, because that is just to test how well your own preparation is. And if you are solid in your preparation, then ideally you would not leave your ground and you would continue stating your point in as many different ways as it takes to convince the judge. Because ultimately, understand this, it's a moot court. Nobody's real lives are dependent on the outcome, right? So even if the debate between you and the judge does not reach a logical end or a conclusion, if you keep stressing on one point and it is the correct point, then the judge knows that despite the judge's best efforts to stymie you or to confuse you, you held your ground and you did not get confused. So that will be on the positive side of the moot.
Thank you, sir.
So we have another question by Diksha. In the competitions where we are to frame issues ourselves, how to decide whether or not to argue the jurisdiction?
Okay, I will approach this question in multiple points. So firstly, okay, there are two types of jurisdictions. The first type is where the court is given the power and is also mandated to hear a case. For example, if it's a suit, and if you file the suit before the appropriate court, then it is incumbent on the judge to hear what you have to say. Whereas in some jurisdictions, those jurisdictions are discretionary. The most obvious example being that of a special leave petition of the Supreme Court, preferred to the Supreme Court. So whether or not you have to argue the jurisdiction in the first place, that depends on what kind of a matter it is. If the matter is one that is incumbent on the judge to hear, then you need not argue the jurisdiction. But if it is of the second kind, where you have to convey the judge why you have preferred this way of coming to the court and not some other way, in such cases, you may have to justify that. So that is a very case specific question, I would say. So that entirely depends on what the problem says. And there cannot be a blanket answer.
So we have another question by Bhagyashree. She's asking how to just tackle the questions by judges and get back to your previous point. So she wants tips for that.
Okay, now one very practical remedy for this is that whenever you go to the dais and you start arguing, list down the bullet points on a piece of paper, write them down on a piece of paper in the sequence that you're going to argue. And as you finish one point and go to the next, even though you're looking at the judges, just keep ticking those points off the list, right? So you know what point you're at just now. And even if the judge through a question or otherwise redirects you to some earlier point which you made and you satisfactorily convince the judge on that point, you can just glance down and know what point you're at, and you can quickly come back to that point. So it's very crucial that you have the sequence clear in your head and you have it written down somewhere so you don't have to think and waste a few seconds in doing that.
Thank you so much.
This is what I do. This is what I have done over the years.
Any other questions? Because okay, till the time if I get more questions, I would just like to welcome Agne Chaudhary, who is also an alumnus of our college, and he has been our sports secretary. So welcome, Agne. Thank you so much for being here. Are we audible and visible to you, sir?
Yes, you are audible to me.
Yeah, so welcome for the session, and we are so very grateful that we also have you in this webinar here today.
Yes, thank you so much.
Any more questions by the attendees? Okay, I suppose there are no questions, and if at all you guys have, Sir has been really kind enough to answer our questions via Facebook. Before we move on to the end, I see that we also have our principal ma'am in the meeting. Principal ma'am, would you be please encouraging us and just sharing your views before we end the session? It would be really nice to hear from you as well.
Okay, first of all, very good evening to Shreyas, and it's really I'm very happy to see him back after so long. And yes, we always have the fond memories of our star mooter, as we used to call him. So I think he has been the person to guide all the young students who are aspiring to become good mooters. Shreyas has definitely brought a lot of laurels to our college and won a lot of mooting competitions. And so really we are proud of him. And the very fact that he's back here to guide all of you really shows his commitment and his love for the college also. So Shreyas, we are really happy to have had you. And throughout this whole 1.5 hours, you have been giving wonderful tips to the students. And really these tips are the ones which you are not going to find in any, textbook on mooting and all that. So I think those tips which were there, which you're not going to find anywhere with, but which are from his practical experiences that he has had, are going to be really wonderful wonders. And I'm sure that with all this guidance that they have just received, as class students are also doing steps and doing many exercises, and as well as they will enhance their personality and develop their careers, shape them in the right direction. So, you have still not completed your LLM. I wish you all the best for its completions.
Thank you, ma'am.
Yes, so wish you all the best for that, and let's hope that we will be soon be able to actually receive you physically also in the college when college resumes once again offline,
Hopefully.
because I think all our students are just waiting very much for that. And though we are very much connected to them online, I think we are missing, we having them in the class and, physically seeing their faces and their
Yes.
happy smile. But you have put a lot of smiles on their faces today. So thank you once again. You've really
Thank
done
you.
a wonderful job of guiding them. Thank you. Shreyas.
It's
I
my
also
pleasure.
thank you, Agnya, for joining us. Agnya, uh, if you could also switch on your
Yes,
camera
ma'am.
for let the other students see you also, because you are also one of our alumni. And we are always happy to receive our alumni back.
Yes, ma'am. Yes, ma'am.
Yes, Agnya. So I welcome you also to this webinar, which you have been attending. And
Yes.
I wish you all the best also in whatever career that you have chosen and
Yes.
where you are
Yes.
currently.
Thank you, ma'am.
This pandemic has really created a situation where we are forced, to just connect online. But yes, it's a boon. At least we are connected. Nothing is always better. I mean, something is always better than nothing. So yes. So I'm
Yes,
happy
Yes.
to see both your faces today. It's always
yes.
it's a happy moment for us when we see our past students and they are doing so well. So thank you
Yes.
so much.
Thank you.
Thank you very much, ma'am.
Thank you so much, ma'am. It was so very nice and wonderful to hear from you. Thank you so much, Reyes, for this wonderful and a profound session full of the tips and the knowledge. So I would like to now call upon Rama Sani to express the vote of thanks. Rama, are you here at the meeting?
Yes, Usha.
Yeah, so could you please turn on your video, Rama? Yeah,
Yes.
yeah. Over to
From
you,
all
Rama.
your from all your experience, it is clear that moot court competitions are fun and that grilling it helps in building up great oratory skills that develop confidence in your ability as an advocate. I, Rama Sane, on behalf of the Sri Navalmal Pirodia Law College, would like to propose a hearty vote of thanks to our guest speaker, Mr. Shreyas Lele, who has devoted his time to introduce us to mooting and the skills are that required for it. Thank you, sir, for your valuable insight and for your guidance. It was an honor to have you as a guest speaker, considering the vast experience you have in mooting. Your command over the subject and your expertise in it is remarkable. We are indebted to you for answering all our questions. Your guidance would definitely prove to be helpful and encouraging to all of us to take our college forward in the future in all mooting competitions. Our sincere gratitude goes to Advocate Nitin Apte Sir, Chairman, D.S. Sri Navalmal Pirodia Law College, Dr. Rohini Hunak, Principal Shri Navalmal Pirodia Law College for their continuous guidance and support. We are also grateful to faculty in charge Anagha ma'am and other faculty members present here. Lastly, thank you for all the attendees for their active participation. Thank you so much.
Thank you so much, Shreyas. It was really an overwhelming session. We've been receiving a lot of messages on our groups regarding the session that it was a really full of insights and a knowledgeable session. So thank you so much for that. And we had almost 102 to 103 people listening to it. So that is really a very nice number for us as well. And it was because of your insights and the knowledge of yours that it was possible. So thanks a lot.
You're too kind.
Yeah. So with that, I declare that the session has been ended. Thank you so much, everyone, for your participation. Thanks a lot.
Thanks.
Thank you, Urja.
Thank you, ma'am.